the morning?
Early in the morning, then tapering off in the afternoon.
Okay. Thanks so much for joining us. Good night.
Prominent Atlanta attorney Tex McIver is accused of intentionally killing his wife Diane in September of 2016 while they were riding home through Midtown Atlanta. McIver claims he fell asleep in the back seat when a loaded gun in his lap accidentally went off, striking his wife, who was sitting in the front passenger seat. Danny Jo Carter, Diane McIver's best friend of 40 years, was driving the SUV that night. She drove the couple to Emory Hospital, where Diane died the next day. In December, about 3 months after the shooting, Fulton County issues a warrant for McIver's arrest. The charges include felony involuntary manslaughter. McIver turned himself in later that night, but was free on bond just 2 days later. Things change on April 14, 2017, when police find a gun in McIver's Buckhead apartment, a violation of the terms of his bond. Later that month, McIver is indicted on new upgraded charges, including malice murder, felony murder, and witness tampering involving Danny Jo Carter, the woman who was driving the SUV. Judge Robert McBurney is presiding over the case in Fulton County Superior Court. He denied bond to McIver once the murder charge was announced, but a few months later, in October of 2017, set bond at $750,000.
There's really one thing that you need to know about Tex McIver and Diane McIver to know that he did not intentionally shoot his wife, and that is that he loved her.
On Diane's death, he went from negative $5,000 to over $1.1 million cash instantly. And he was the executor and one of the beneficiaries of Diane's $7 million estate. It was aimed right at her back.
He's fallen asleep. When I get back in my car, the gun just discharges and goes off.
And she's driving as fast as she could. And she says the defendant tells her, slow down. You can get this case dismissed. And if you do, there's a large bonus in it for you. And I won't mind if you share it with the DA.
You said she made loans to the defendant, Mr.
Yes.
McIver. And did she expect Mr. McIver to pay her on time with interest?
His loan was interest only, so he only paid interest.
Okay.
He didn't pay any principal.
Now, you said his loan. Tell the jury a little bit about his loan and what the loan was for.
The loan was for $350,000. I'm not sure what the loan was, what the money was given to him for. It started January 15th of 2012, and he made interest-only payments. It was a 3-year term originally, and the payments were $1,531 a month. And at the end of the 3 years, Diane came to me, it was January, I guess, of 15, to say, I've re-upped the loan for another 3 years, and I've reduced his payment to $1,400 and something dollars. It wouldn't be in the checkbook registers. It was a whole, I had a file for each person that had a loan out, and each month it had the amount of the payment, and then I posted the payments as they were being made.
Okay.
So there is a spreadsheet for that someplace.
The loan was for $350K?
Yes.
And it was how many years?
The original was 3.
Okay. And that started when?
January 15th. The payment was due on the 18th of the month, and it started in January. I think it was 2012.
And it was 3 years from there.
Yeah, and it was $1,500 and some change a month. My partner is an interior designer, and the condo, the second condo, when they put them together, the kitchen was torn out. It was just a big party room with a bedroom. And Tex had asked us what we thought it would cost to put that condo back as a condo, if he wanted to put them on the market.
When you say put that back, you can split them back up into two condos.
Right, and you'd have to put the kitchen back in, and put it back together.
And sell them separately.
Yes.
And this was less than 24 hours after Ms. McIver.
It was either I went Monday night, Tuesday night, and Wednesday night. It was one of those 3 nights.
That sounds like a funny question. Take a minute.
Do you need a break, Mr. Brown?
I'll be all right. Just give me a minute. It's what my job was, and that's how I saw it. It was very important to me to finish. I'm sorry.
Just take a minute, take a deep breath.
I didn't think it would be this hard. It's been too long. Okay. So that's why. It was important to me to finish her life.
Because her money was so important to her.
It was important to her.
I'm sorry, objection.
Stop doing that. Don't argue through your questions. Save that for, if you want to give closing, negotiate with Mr. Ruther and his company.
Did he, after showing him your documents, your spreadsheets, did he say anything about her finances?
Well, he thought she had more money than what she had. He was surprised at the number that was in her checking accounts.
And if you do me a favor, would you describe to the jury that evening the observations, the times that you saw the defendant throughout the night? What was his demeanor like?
He was emotionless.
Can you kind of explain to her, what do you mean by emotionless?
He did not appear to be upset or distraught.
Objection, Your Honor. Her opinion of the demeanor.
Number two is Ms. McIver trying to speak to you. Is she able to speak to you?
When I entered the room after I had spoken to her husband, she was starting to ask questions. She asked me if she was going to die, and yeah.
And was that all the questions that she asked you?
Yeah, she just asked me. She looked at me and said, "Am I going to die?"
And when she said that, did you say anything to her?
I said, "No, we're gonna help you."
Okay. Now, while she's in that room, is anybody else trying to speak to her?
Yes, Dr. Hardy is speaking to her.
Okay. And is Ms. McIver responding?
She did respond, yes.
And without telling me what Dr. Hardy said, what did you hear Ms. McIver say?
I just heard it was an accident.
And when you heard her say that, was that after you spoke to the defendant right outside of Critical Room 2?
Yes.
Okay. Now, is that all that you heard her say, or did you hear her say anything else after that?
I believe at one point I heard her say, "It's hurting," and that's it. At that point, we still hadn't located the gunshot wound. It wasn't evident, like I said. So I started questioning him. I leaned in kind of a comforting manner and said, "What happened? What's going on?" And he said to me, "It was an accident. I had the gun in the back seat, and it just went off, and it was an accident."
So let's break that down. So you ask him what's going on, and does he answer you immediately?
No, it's a delayed response.
Okay. And when he finally responds, what's the first thing he says?
He says it was an accident.
And were you there this evening?
No.
Were you there this evening?
No.
Good evening, everyone. I'm Vinny Politan. Welcome to our Facebook Live program, Late Feed Law, day 4 of the Tex McIver trial. Another unbelievable day inside the courtroom. We heard from 4 Emory University Hospital workers. You had nurses, doctors taking the stand, talking a lot about what Tex McIver was saying and doing in the hospital. And it all comes back to one thing that he told to a bunch of different people in different ways. His story about what happened in the back of that SUV. But the story always ends the same way. The gun went off. How does a gun just go off? Well, tonight we're going to try to answer that question for you. I've got my legal dream team with me. This is Charles Middlestad. He's a high-profile defense investigator and gun expert. He's been in all the big cases down here in Metro Atlanta. In the front seat, LaTonya Hines. She's a prosecutor up in Cobb County. All right, so we got our team set tonight, and I want to start over here. And by the way, folks, I'm monitoring what you're saying as well, so you can send your questions or your comments. We'll get to them, post and repost them. Let's start here. Charles Middlestad, you're a gun expert. This is from the defense opening statement. They posted a bunch of pictures in their PowerPoint. This is the gun. Tell me about this gun, Charles.
It's a revolver. It's a .38 caliber revolver, and here are the unique things about this particular gun. First of all, it's what's called a carry conceal gun. And the reason that is because it has what's called a shrouded hammer. Usually you'll see in a revolver, you're going to see the hammer that people are familiar with.
It sticks up in the back, right.
That's correct, and that's how you cock the gun. In this particular case, because it's shrouded, it's designed to be concealed so that you can put it in your pocket and it doesn't accidentally get snagged.
I think I have a close-up picture of it right here.
That's right. There's the actual hammer itself.
Hammer you're talking about.
Now,
so what's the advantage or disadvantage of that?
Well, again, if you're going to use it for a carry conceal, you don't want something that's actually going to get snagged on your pocket or in your purse or something, and that would accidentally cock the gun. Okay.
So this one's more difficult to accidentally cock. Is what you're
accidentally
saying?
Cock, absolutely.
More difficult.
More difficult.
Accidentally. Okay, that's important for this case, I think.
Potentially.
Okay.
Now, the thing about revolvers in general is that they don't have a safety. Unlike an automatic, which some people in our audience may be familiar with, where you have a slide and you have a safety, so you can actually have the gun loaded, but in a safe mode, and then you make it ready to fire by disengaging the safety. Revolvers don't have that feature, and you have either a single action or a double action. This happens to be both.
What does that mean?
So single action means that you can cock the trigger,
pull back the hammer.
You cock the hammer.
Okay.
And it's going to make the trigger much easier to pull. Okay. And so on this particular weapon, when the hammer is cocked, the trigger pull is less than 4 pounds. It's already, and it can be adjusted.
Put that into English for me. Less than 4 pounds. Does that mean I just touch it and it goes off?
It's pretty light. It's pretty light, and I think there may be evidence in this case that the trigger pull on this exact weapon was actually even less than that.
Less than 4.
Less than that. Okay. Potentially 2.5.
Now, if the hammer's not back, how difficult is it?
That's the double action part. It's very difficult. You actually, that's up to 12 pounds worth of pressure necessary to squeeze the trigger.
All right, I'm just checking in here, Charles, just to see if folks had any questions for you about that. All right. Only got it. Text no. Want to be with the jurors, Queensland, Australia. Thank you for joining us. All right, here we go. Now, so
right here.
Yeah. Now, so this is it. Wait. Oh, there we go.
There we go.
Hey, he's jumping all over. By the way, now we have some other photos here, again shown by the defense in their opening statement, which show the trajectory of the bullet that killed Diane McIver. We're going to take you inside of this SUV to demonstrate it even more, but I want to show you the pictures first. Charles, explain what we're looking at here.
Okay. These are actual photos of the vehicle, and these are recreations that were done. It's unclear to me whether it was done by the defense or the prosecution, but in any event, there's evidence markers here, and you're going to see a trajectory rod that exactly follows the trajectory of the bullet that went through the seat of the projectile. And so you can see here, this is a view from the back of the seat, and what you'll notice is it's actually very low, Vinny. It's indicative of something that would have been potentially on Tex's lap.
Potentially.
Okay. The defense, in all likelihood, will argue that it was on his lap. Now, it could have been facing, an upright position, or it could have been laying down.
You're going to show us in the back. You're going to show us in the back. Now, this is where it exits the seat but enters Diane McIver.
That's correct, and it's actually pretty low. It's in her lower back. Okay. Now, in order for it to traverse the seat, you notice it has to go through all sorts of mechanisms here. This is equipment that's inside the seat that's designed to allow it to adjust. It's an electric seat.
So they opened up the back of the seat and are showing us what's inside, and this red circle signifies where it went through. That's where the bullet traveled?
That's correct. So it started here, it went through here, and it exited here, and then entered Diane McIver's back.
Here we have just a wider shot, and if you look really closely, right here you can see that's the bullet hole right there in the back, so you can see where it is relative to everything else, so you get a better perspective. And we have another shot of the front seat as well. So let's do this now. Let's get into the SUV right now. Keep the door open. And the first thing we got to talk about, and LaTonya, this is is the gun up there? The gun's back here. The gun was in the console, right?
Right.
So if you're Diane, you're taking the gun out of the console.
Yeah.
And giving it to Tex who's in the back seat behind you.
Okay.
All right. Here's my first question for you, Charles. The gun's in the bag.
Yes.
How does a gun just go off if the gun's in a bag?
Okay. If the gun was actually cocked, if the hammer was cocked, and the one thing, and I've actually done a little bit of reading up on this particular gun, and there's actually some criticism by reviewers who are familiar with this gun, who have reviewed the gun for other gun enthusiasts, about the fact that this shrouded hammer is really tricky to operate. And in fact, even when you intentionally want to decock the gun, it's actually pretty tricky, and it requires using both fingers to do it.
Let me ask you this question, and is there any way that you could accidentally double action shoot someone with that gun?
In my opinion, I don't see how that's possible.
So they can't make that argument. You agree, LaTonya?
I mean, I'm going to trust Charles.
You can talk to
I'm going to trust Charles with regard to his analysis. He knows what's going on with regard to guns and ballistics.
It's a 12-pound trigger pull in double action, and that would be very difficult for me.
You can't accidentally double action shoot someone.
No, I think that would be a very difficult argument to make.
You really got to pull and squeeze, and you're doing it through a bag. Through a bag.
Well, I mean, it's just a plastic bag. So the bag itself doesn't really, to me, it doesn't have that much significance.
Well, yes, it does.
Here's my question.
To get your finger on the trigger.
Well, but because look, the bag doesn't provide any resistance. Now, in the single action mode, it doesn't provide any resistance. I mean, if you accidentally hit that trigger, it really, in fact, some of the reviews that I'm referring to mention the fact that it's almost too light a trigger.
Well, let me ask you this question, because part of the defense's opening statement is about this compulsive arousal or theory that maybe...
But not compulsive arousal.
What was it? It was something...
Whoa, that's a whole different thing.
Oh, sorry.
It was REM behavioral disorder.
No, but they also said compulsive arousal. Yes, I kid you not.
Wow.
They did.
Wow.
And they said that when he woke up, he had this sleep issue, and then when he woke up, that he would just be startled.
Right. And I don't think that's inconsistent with the argument. First of all, let's talk about why the gun could possibly be in a plastic bag.
No, I want to know why it's in a plastic bag in single action mode, because that is absurd.
Well, it is a Publix bag, though.
All right.
Where shopping is a pleasure.
Yeah.
All right. So, I mean, the possible explanations for that are, first of all, we don't know who operated this gun before. and they may have, you know, it's clearly not good gun safety. There's no question about that. It's certainly reckless to put a loaded gun that's been cocked in a bag in a console. That's bad.
Whose gun is it? Let's remember. Whose gun is it, Latonya? Do we remember?
Well, we don't know who last fired it, but clearly the fact that it was, you know, if the argument is that it was cocked.
Didn't Tex say, "Give me the gun"?
Yeah.
Right. But the point is, he did not take the gun out of the bag. The gun was handed to him in the bag, and that's how, and it stayed in the bag. And I think the evidence is going to show that when it was fired, it was still in the bag, because there's going to be gunshot residue in the bag.
So what does that mean? What does that tell you as a prosecutor if the gun's in the bag?
I mean, here's the deal. Either way it goes, even if the gun's in the bag, and I hear what Charles is saying, if the prosecution's theory is that he took this opportunity to do this, the reason why you want to have it in the bag is because it makes more sense of saying it was an accident.
Yeah, but then that's if you take that piece of evidence in isolation. If you want to say it's an accident and you want the maximum effect for, to carry out her death, you don't do it in the middle of downtown. You don't do it near Piedmont Park. You do it somewhere up I-20 when you're not anywhere near a hospital.
Here's what you forget. Just like Scott Peterson, not every person who kills somebody intentionally is smart.
Wait a second. You're just arguing the opposite. You're arguing that he would have planned all these things. So is he smart or is he not smart?
No, but they do partial.
I mean, you got to pick.
They think that they've planned everything out.
So
and it's not.
Here's. And I know plenty of gun owners that the fact that this was in a plastic bag, to me, is more consistent with someone. Listen, cars get broken into all the time.
I know that,
because thieves are looking for guns. It's one of the easiest things for them to pawn or sell on the street. So if you have somebody who's committing a break-in and they're very abruptly, very quickly going through the console and everything, they may pass this up because they may not, they'll pass it up because they aren't going to look to see what's in the bag.
I mean, it's not that much of a disguise, though, Charles.
It's enough of a disguise, absolutely. If you put this in the bottom of your console in a bag and someone's looking for a phone or loose change or a wallet or whatever, they very well may pass this up. Well, that's one of the things they're looking for. They're looking for anything that has some value so they can get their next high. And that's
let's do this. Let's do this. Take the gun out of the bag for a second, because we attach a rudiment, and it's a toy gun on purpose, folks. We don't want it to look real. We don't want anyone to be scared that we're playing with guns here. We are not. I've got a laser pointer next to it.
This one's pretty fancy.
Yeah, this is pretty fancy. So we've got a laser here. Why don't you take a look with that laser? Put that thing on your lap and
well, again, this seat's not very representative of what we're dealing with.
It's not the same car.
Right. I mean, the photos themselves speak better. I think the defense's contention is that the gun was in the bag, laying on his lap, and that's going to be very consistent with the trajectory and the height of the entry hole.
The entry hole was about this high.
Right. So this is
very the laser so we can see it.
Will it matter about how?
This is very consistent, okay, with the gun being on his lap, and you can argue that it was laying on its side like this. Could have been sitting between his legs in the bag. I mean, either one of those is possible.
How was he sleeping? How was he sleeping? So supposedly he was in the back.
So he fell asleep. Right, he falls asleep for a second. I mean, I've fallen asleep in the back of a car plenty of times.
Yeah,
Did you notice there was a bottle of wine in that photograph?
There is. There's a bottle of wine.
And they had been the Longhorns.
There was alcohol in his breath. We had testimony today from more nurses and workers at the hospital, all saying that he had alcohol on his breath.
Right.
There was testimony from the waiter at the Longhorn in Conyers that it was very unusual that they ordered a bottle of wine.
Of course,
of alcohol.
No, keep that laser on for me if we could.
We don't. But if we're going to be objective about the evidence, there's nothing about the evidence that is inconsistent with the argument that the gun could have been laying on his lap.
Let me get to
now,
a couple
the only possible
here.
argument that the prosecution could make is if this was intentional, is that somehow he had it by his hip or something. But I don't even think that's possible based upon the trajectory.
But here's the deal.
Because you would have a different angle.
The deal. What if he has it laying on his lap, but he still uses that opportunity to shoot her?
I mean, that's entirely speculative.
Well, right, of course.
Right, but
that's what the whole case is.
Here's what LeClaire wants to ask
but
tonight.
you also have to look at the likelihood based upon the evidence.
These two just going at it tonight, right? Prosecutor, defense investigator. LeClaire wants to know, how much does the mechanical workings in the front seat affect the impact of the projectile? Would hitting a bump in the road cause the gun to automatically discharge? Because one of the stories we heard today in court was that Tex McIver told one of the nurses that he was in the back and they hit a bump and the gun went off. How, in your mind, could
if he has his finger on the, near the trigger and they go, if his finger, this is...
Well, again, let's want to put it back in the bag and show me?
The bag doesn't. The bag doesn't provide any resistance. Let's keep that in mind. It doesn't provide any resistance. What it does is it obscures the gun. Is all it really. The only purpose it really serves is obscures the gun. But if your finger is, near the trigger guard and you go over a bump, potentially, given the very, very light trigger, if it's in the single action,
but it would have to be cocked.
Which I think is the argument. I think the defense is going to argue that it was cocked. I don't think it's a compelling argument, nor do I think it's very plausible that if it's in the double action mode that somehow any bump is going to cause a 12-pound trigger pull.
Correct.
So how does that fact play with the jury, you think, Latonia? The fact that Tex McIver would have had to had in the console in his car a gun cocked and ready to go, sitting in a Publix bag.
But it's that gun, and that gun in particular, you can't ignore the fact that it's got this shrouded hammer.
Did I ask Latonia the question?
You did ask me the question.
But Latonia loves to defer to me on weapons
but
questions.
Here's the deal. If we're still going with the idea that he, on some levels, had been planning this or wanted to have this happen, then even though you're saying that certain things had to happen, well, guess what? He would have had to have it cocked. If you want to go with this whole idea of there being an accident, is it more plausible in having an accident theory to say, oh, well, yes, when I got the gun, it was already cocked, we ran over a bump, something happened, and then that's what caused the death?
Yes, but if that's your plan and this is an intentional act, is what you're inferring, then why would you possibly do it right near Piedmont Park in close vicinity of all these hospitals when you're on your way to Athens?
Don't go down that road right now.
Near all those hospitals that you bypass with regard to your wife when you actually do shoot her. Like, you don't go to Grady, you don't go someplace close.
But he's not, listen, you and I, we do this sort of work and we deal with these violent cases
Wait. I'm sorry. It doesn't take being an expert to know that I just got shot or somebody in my vehicle shot to try to get them, call 911, which every kid is taught, or try to get them to, a really good hospital.
Right, and Emory is a really good hospital. If you're unfamiliar with...
If you are from Atlanta and Tex was here and lived here long enough to know...
50 years.
Everybody knows if you've got a gunshot wound, a severe burn, where are you going?
Yes, I'm saying you and I know that because of what we do.
And that's do you think that Tex, as an attorney, didn't realize that?
He doesn't do criminal work.
But that's even more so, a civil case.
Well, prosecutors argue they did some criminal work in this car. All right. Here's from John Proper Sr. Putting a gun on your lap. How in the world can this gun go off unless her husband had to hold it in his hand and point it at his wife's back at the hospital? She didn't want to see her husband. Wonder why.
I still think that's a really big point.
The doctor even says, the doctor is going to testify that that's not unusual at all, that she was under all of this medication. She's got lines, PICC lines, IV lines.
It's not unusual at all. This is the part that is a human part. Okay, and I said this to Daryl.
She wanted to see her husband under better circumstances.
Well, you know what? Would have been a better circumstance not being shot, obviously. But here's the deal. If you might be dying, wouldn't you want to let him know that, guess what, I don't hold you responsible for this?
She told other people it was an accident.
But you know who she didn't say that to? She didn't say it to Tex.
Latonia, listen.
I think it's a big deal.
You're going to have to open your mind up to certain possibilities.
I understand opening my mind up to possibilities.
Now, trajectory-wise, consistent, would you agree, Latonia, that it's consistent with on the lap? From what I saw over there and what I saw over here, that's the trajectory. Is there an argument for that trajectory for prosecutors?
I think some part of it that's a little bit of a problem is that why would he want to shoot that low? That's part of an issue. And trying to explain that.
So you're saying that's a problem for prosecutors that you admit?
Yes.
Okay.
Listen, I would think that...
Charles making some headway tonight.
I would think that the argument would be... I know.
All right.
I'm able to...
if you were going to take this accidental defense claim, this accidental claim...
But who says
then why not hold it up and, shoot her in the neck, shoot her in the head?
This is the best point that I think was made tonight by McIver. if you're holding the gun for protection of your wife, why are you dozing off?
Oh.
Why are you dozing off? Because he was startled. We're in a bad neighborhood. Black Lives Matter might be here. Give me my gun. And then I fall asleep.
Right, and then maybe
and we did this drive the other day.
Also, why keep it in the bag?
No. Why do you think that the jury will buy an argument that he was so worried, so fearful, yet was able to doze off?
I think that's a great point.
I think
it's a great point.
It's very situational in nature. I think at the moment that his concern was piqued, maybe there was a crowd around, and then maybe they went a little further down the road, and nobody was around.
We timed it out, and it took us like less than 8 minutes to get.
I mean, that's a long time. I mean, you could
listen,
pass what you perceive as the danger, right?
But
and then you fall, you doze off for a second.
But that is the art of this case.
Maybe when you pass the danger, you put the gun away.
But this is the art of this case.
Yeah, but if we're dealing with some sort of alcohol-induced event, right? We're talking about poor judgment.
So now
we're talking about reckless conduct.
Now you're saying it was all alcohol?
No, I'm not saying. I'm saying I'm considering all the possibilities, and I'm not going to consider one thing in isolation. You got to put it all together.
Well,
it's a circumstantial case.
If you put it all together,
you got to build the
then what about some of the things that happen afterwards, which is what I think prosecutors, I think that's what prosecutors were looking at, because originally he had one set of charges, and then things happen, and then he has another set of charges.
Yes,
you know why?
That has mostly to do with his mouth.
Yes, but here's the thing. That's what happened here. You think it's an accident, it's meant to be an accident, and then you start seeing more and more things, and it makes you think, wait a minute, this wasn't an accident.
Well,
let's
this is
see,
where we're at,
Let's
folks.
see what they learned from the time they originally viewed it as an accident to the time that they charged him, indicted him in this case. What additional evidence did they have, and what caused them to change their perspective on it?
Let me ask you this question, Charles. Is there any place in your mind where you could think that this actually was intentional?
Listen, this is the trial is in its infancy. I haven't seen evidence yet that would convince me as a juror yet. And again,
what jury is he getting on, right? Hey, great job tonight. Charles Middlestack, defense investigator. We've got LaTonya Hines, awesome prosecutor. Thank you both, members of my dream team. We do this every night at 7:30, folks. We take you inside the evidence tonight. We return you to the scene and try to analyze what's taking place. Remember, the trial will be streaming every day on our Facebook page. Begins around 9 o'clock in the morning, goes all day long. And then tonight, 11 o'clock on the late feed, we'll put together some analysis with some of those big moments from the courtroom to get you ready for tomorrow. Thanks so much for watching, and we'll see you tomorrow night, 7:30 and 11 o'clock on the late feed. Great job, guys.